Some were taking all this down, and we're streaming live on YouTube. And we have the great Buddy Lowe, who is the chair of our evidence subcommittee, and will take up the next item on our agenda, sexual assault survivor privilege. Buddy?
Let me not hold myself out as an expert in sexual assault, but I've been asked to report on it. This assignment was from the Chief Justice, which asked us to consult with the State Bar of Texas Administration of Rules of Evidence Committee and consider whether we should write a rule following the new amendment, or should we have a comment, or just what we should do. We have always, in our evidence committee, have committed things to the State Bar, AREC, and then they would give a report. We would review that report and try to get together. Well, unfortunately here, their membership is changing. The chairman of that committee goes off Monday, but I have had a telephone conference call with the incoming chairman and with him. And I have been in communication with our committee. And for background, most of you might already know this. Senate Bill 295 amended Chapter 420 of the Government Code to provide a privilege for victims of sexual assault, or particularly people associating and helping victims. There was already a privilege for victims of domestic violence. And so apparently the legislature wanted to make them equal. All right. Well, the first thing I did was call Professor Good, who is a long stay on the AREC. And I sent him the material, and he responded back that we should do nothing because there are about 15 or 20 privileges that he knows of that are not in the 500 section. I sent all that to my committee, and I agreed with Professor Good. Unfortunately, nobody on my committee agreed with me. Some wanted to draft a rule like 295. Most wanted a comment. And I responded back and I said, if we have a comment, then what do we do with the comment? Where do we put it? At 501, do we also state that there are many privileges, legislative privileges that are in existence and not here? And then if we put that in a comment, then do we overshadow the domestic violence violence privilege? I mean, what to do? And we've not gotten beyond that, other than a majority of my committee does favor the comment. And with that, Roger can give you some of the help. Now, I do point out, let me read, that the only reference in that amendment, they do refer to the rules of evidence. And they say, let me find it. Let me turn here, hold on just a minute. They say, notwithstanding subsection A and B, the Texas rules of evidence govern the disclosure of, and they talk about communications with regard to expert witnesses. And as you know, expert witnesses under 703 can rely on privileged material. And so the question was, we want to do what the legislature wanted us to do. Do they want us to do anything? Do they want us to draw a rule or what? But I do point out that they do mention that. And in other times, they have asked us to draft a rule, a procedural rule, according to a legislative directive. All right, Roger, do you have something to add?
Yeah. Let me explain a little bit about what this privilege is. And he is right. but he's right that most of the committee favored a comment, but there was one minority view that we do nothing. And then there was another minority view that we try to write a rule. Now, what it is you have Government Code Chapter 420, which creates or authorizes the creation of nonprofit corporations to provide sex assault advocates to victims of sexual assault. And then later in the chapter, it creates a privilege. And what Senate Bill 259 did was it expanded the privilege and codified some waivers. Now, to bring it to a point, nothing in Senate Bill 295 asks the Supreme Court to write any rules at all, rules of procedure or rules of evidence. That's nowhere in it. What it does is it expanded the privilege to cover not just communications between the advocate and the victim, but also to cover the written records of the advocate. And then in the next, it amended the section on the exceptions to the privilege. One is for exculpatory records that the court has. Now I'll come back to that in a moment. The second of it is in the exception section, it says that the Texas Rules of Evidence will control disclosure of underlying facts if the expert gets on the stand. We all know if we have a testifying expert, the expert doesn't have to disclose their underlying facts that they're relying on. But if this expert has reviewed confidential records or communications, the court has some leeway under Rule of Evidence 706, first to allow the opposing counsel to explore that on voir dire, and second to perhaps have the jury hear it. The next one is that it created a new motion in criminal cases. And it set out exactly what has to be in the motion, how it has to be verified, and what the judge has to do to allow access to exculpatory information in the records. And what my opinion was after looking at all this is that, number one, trying to write a rule to encapsulate this or paraphrase it would be impossible. It's the whole several sections about the privilege, the exceptions, waiver are several sections. They're very detailed. I just don't think we can write a rule to encapsulate them all other than to quote the rule itself. The second is, it seemed to me that this was a legislative compromise because the bill went through several versions, and it seemed to me that there was, shall we say, something going on in the back room between the advocates and the criminal defense bar. And any attempt to paraphrase this rule, trim it, encapsulate it, whatever, is going to look like we're trying to upset the legislative apple cart. And furthermore, we've got a situation where people who are involved in this probably know this statute already. The advocates are going to know it. The criminal defense people are going to know it. Now, to give some credence to the minority view that we do nothing, not even a comment, Professor Good did give a very lengthy list of statutory privileges. And he said that is not complete. And if we have a comment, say, for example, to Rule of Evidence 501, which is the general rule of privilege, everybody's going to have a what about me too? I have a privilege. There's this privilege and there's that privilege. And if you mention one, then they're all going to say equal dignity, mention me all. and it could get lengthy. On the other hand, the issues of family violence and sexual assault are very extensive. And I don't practice criminal law, but I suspect they occupy a considerable portion of the court's docket. I'll defer to trial judges if it's about whether that's a valid viewpoint. And so maybe mentioning it might be of some help. I don't know. Anyway, those are my comments. Thank you.
Chip, you can understand why I said I feel comfortable when I have his backup. He's now the committee, Roger, one of the things that they are considering is whether they can do this through Rule 510, mental health. I don't know how they can. What do you think about that?
Well, I don't think it's a neat pigeonhole to fit the or to try to incorporate it into Rule 510. Sexual assault advocacy, in some senses, is broader than physical and mental health, whereas Rule 510 is limited to communications with professionals who deal with mental health issues. Sexual assault advocates may deal with a broad range of issues. And there may be information that they acquire about the victim that might not be pertinent to treating them for an illness or counseling them about mental health issue. I'm just not sure it's a very neat pigeonhole to try to say this is more like mental health. My personal opinion is that sex assault advocates are more like social workers that deal with the whole person and all of their problems that arise from a particular situation, and not just their physical, treating them for their physical or mental condition.
All right, Chip, you've heard our report. Now, the chairman of the AREC has told me that they will begin immediately working on that and try to get something out, as quickly as they can. But under our procedure, unless we're asked to do differently, we always get an opinion from them, and the joint opinion that's gone on for a long time, and it's worked well. And in the meanwhile, I've asked my committee to draw their own conclusions and be able to go forward. So we're staying abreast, and now we're waiting on the AREC. And if Chief Justice Heck would like for us to start drawing a comment or doing something, I'd be glad to do so. But traditionally, we've waited to hear from the AREC.
Well, I'll defer to the chief on that question, but I think the court was interested in getting this committee's views, and unfortunately, it had to be expedited because the statute goes into effect September 1, and the court needs, of course, time to decide what to do if they're going to do anything. So we'll get to Lonnie in a second, but Chief, do you have any response to Buddy's thoughts or comments?
Yeah, well, I think it'd be a good idea because of the timing to go ahead and get the committee's views on the subject, and then we can check the AREC in the next few weeks after the bar year changes and they get settled.
All right, I have already sent my suggestion of where we should put it, and my suggestion of basically what the comment is or should be. And I've heard nothing about that. My suggestion was, again, nobody has in my committee has responded to this. My suggestion was we put a footnote for this, an example of legislative privileges or this, although there are many other legislative privileges. We don't list them all. That was, I didn't draft the comment, but that was my suggestion. And I've heard nothing. I will ask the committee, since the majority of the committee want a comment, I will ask them to start to work on what the comment would be and what it would say.
Okay, Professor Hoffman.
Thanks, Chip. So I guess I serve on the subcommittee here.
Right.
We had an awful lot of email discussion about this. And I guess it may be, you know, I guess one could read the email discussions differently, but I mean, I guess the place I disagree with Buddy's characterization is, I mean, I think we largely are unanimous in that I don't think there's anyone who's supporting a rule change right now. And so I just want to make sure.
Nobody has one member was, and he's backed off.
So I just wanted to clarify for the whole committee, there is no one on the subcommittee who is supporting a rule change. At one point, Levi was, but he isn't now.
Right.
And so we're really left with just the question of whether we should do nothing or whether we should add some reference in the form of a sort of a comment or something somewhere. And I mean, I thought Roger did a pretty good job of summarizing some of the issues. And, you know, as Buddy says, he raised one suggestion of one possible alternative. And I mean, we certainly, if the court wants us to go in that direction, we certainly can. I mean, I guess I'll just add, you know, I looked at all of the legislative history that I could find on this. And although there isn't a lot, as usual, that sheds a lot of light, at least in the House Judiciary and Civil Jurisprudence Committee's report that came out, the first paragraph emphasizes that the state law currently doesn't provide survivors of sexual assault with the same confidentiality protections when they're seeking a crisis center's assistance as current state law does as to survivors of domestic violence. So, and let me just repeat, that's what the House Committee's report asserts. And so apparently the legislative effort here was to make the goal of the new statute was to make Texas law consistent for victims of domestic violence and of sexual violence. And so that, again, that may or may not be a correct characterization, but that's what I took away from the legislative history, which I think could be helpful in informing our thinking about what we should do here. The only other thing I'll add that I'll stop there. That's enough. Thanks.
All right. But one of the things, didn't you say that you got the impression they wanted to treat those equally? And if we comment on one and not comment on the other, would we be treating them equally?
So that's a good point. But again, there's no reason that we can't do both. In other words, we might say, for instance, that victims of domestic violence and of sexual violence have protections under statutory law that are not codified here in any part of the rules. Go look them up.
I agree with that. So, Chip, as I understand what we're to do is start working on a comment, because that would be approved by most of my committee for add a comment. And now the details of the comment would be left up to us. And I will try to keep the State Bar Committee informed of how we're going and what we're doing.
Yeah, well, I think we ought to finish our discussion today to the extent anybody has further comments. And then if your subcommittee is going to do additional work after today and propose a comment that you all agree on, then I would think that needs to be done pretty quickly, because the effective date of this statute is September 1. The court right now is very occupied with trying to get all their opinions out by the end of June, as has been their custom for the past several years. So, I would think that they would need something from us, if we're going to provide it in writing, by the in a couple of weeks.
I understand that what had held me up was the traditional way. Now, this is due September 1, as I read the bill. Isn't that right?
That's when it becomes effective.
that's when it's effective. I understand we can't wait till then. All right, I will have the committee start working on the comment, and we'll go from there.
That'd be great, buddy. And then give it to, obviously send it to me and to Shiva. We'll distribute it to the full committee. And we're not going to have another meeting before September 1. So we'll provide any comments the full committee has. But that's the timeline. And we'll continue our discussion today if there are any more comments. Does anybody else have anything to say other than what Professor Hoffman and Roger have added?
This is Harvey. I have a comment. One, on the September 1st deadline, because the legislature is not requiring a rule, it does mean that we could decide to have a comment, have that after the fact. Since right now, at least we're getting indications that the committee from the state bar thinks there should be no rule at all, which means if we don't do anything, we'll be just doing exactly what the state bar committee is inclined to do, and that we could do it after the fact. Secondly, I think one of the bigger problems for this is where to put a comment, and I haven't found a place that I really feel like it goes very well. And to that extent, it occurred to me after our email exchanges that we could have a new rule, Rule 514, that would be entitled Statutory Privileges, that would basically just say these rules are not exclusive. There are also statutory privileges, and just keep it that short to remind people to check to see if there is one. That puts it in a place that's easy to find, and alerts practitioners to the issue. We were a little sensitive, or at least I was sensitive to the fact that maybe we want to highlight new privileges because practitioners may not know them. On the other hand, anytime if we were to start listing them, not only do we have the problem of a long list and maybe inadvertently missing some, even Professor Good said he didn't have an exhaustive list, but changes that occur in those privileges. So that would be a problem in listing them. So I think we were pretty set on we should have no list. The comment would be fairly general if we had one. So I throw those out just for the committee reaction, if they have any ideas on if we have a comment where it should go, or would it be simpler to have a rule that just says there's other privileges. And I'm seeing Rich Phillips comment here, and I just have to double check, frankly. 501, I have it somewhere on my computer right in front of me, but I don't see it right now.
So the record's complete. Rich Phillips has sent a message that says, doesn't TRE 501 already do what the proposed comment would do? So that's his question.
And I'll just read it. Unless the Constitution, a statute, or these or other rules prescribed under statutory authority provide otherwise, no person has a privilege to. I mean, doesn't that already flag people that there could be a privilege in a statute somewhere? What would a comment do that sentence in 501 doesn't already do?
That's a good point. Professor Good pointed out that one of our most important privileges is the Fifth Amendment. And we don't mention that. But the rule does mention what you said, statute or constitution.
Yep. Judge Esteves.
So this is my ignorant question time, since other people got to say that. When I looking at the statute that they passed, it's a privilege for sexual assault survivors. And my question is a sexual assault survivor someone who is claiming they've been sexually assaulted, or someone who has been adjudicated as a sexual assault survivor? Because I've had so many cases in which the counseling records have come in to determine whether or not a sexual assault ever even occurred. And if a sexual assault survivor does not include an alleged sexual assault survivor then the most important thing we need to do is to let people know that it doesn't include that. So I would suggest that we need to find out if what this privilege really is would be more helpful than determining where we put it, because it's going to change our litigation, especially when we're talking about children. So we have so many counselors that come in to talk about the advising and the counseling when we have children as victims. And right now we've just privileged a huge amount of information before we determine what a survivor is. And maybe there's litigation already there that determines that. I don't know. That's why I'm ignorant. But we do need to do something with this if a sexual assault survivor does not include an alleged sexual.
It does, Judge. The statute defines survivor as an individual victim of assault, regardless of whether a report or conviction is made in the incident. So, and then the second point I'd make is, I think the issue you're raising is really more of a statutory construction question rather than one for us.
I would agree, but I would also, I mean, it's going to be so important.
I mean, you're going to have people, volunteers helping somebody that has been sexually assaulted. Maybe the person hadn't been convicted or they have. I don't see how you can draw a distinction unless the legislation did and it didn't.
Well, I think you draw a distinction if we're talking about a case in which you're trying to determine whether or not there's a survivor. I understand that there's not a conviction, but let's say that you're in a civil case and whether or not that person was ever sexually assaulted, I mean, it'll be privileged because when you're getting your, I mean, right now they usually don't disclose it anyway, or it's ex parte. And they give it to us to review in camera, but I just don't know where this is. It's been the most helpful probably for juries to determine what the facts are or what they believe them to be, have been these records. And I don't know if you just, and I understand it's legislative. That's why I said it was, that was my ignorant part. I understand that that's the statute that they passed. And when I was reading the rule in the government code, I didn't necessarily see that the words, regardless of whether they've been convicted, would make a difference in a lot of scenarios. So you could still use it to determine whether or not it's a sexual assault survivor. And I just think that if we know that in some other area of law that it's already been established, then we should point that out in some sort of notation when we're doing this other part. It would be helpful.
I mean, we can't change the legislation. Under this legislation, what would you suggest we do? Should we draw a distinction, or what should we do? Should we try to define sexual survivor? The legislature didn't do it.
But they did. They just didn't make it very clear.
Okay, what should we do as a committee within our limits?
I think we should be consistent if we're not going to put a lot of comments on every specific place we change or we add privileges, then we should probably not do that. But I think this is such an important change for family law cases and potentially criminal law cases because of impeachment issues that everybody needs to know this. But I guess
I know, but how are you going to do it without changing the legislation? I mean, we're limited. We can't change. So I'm limited to what our committee can legally do. If somebody has a suggestion, I'm open to suggestions because I have no answer to that.
Well, let's hear from Justice Christopher, but then we need to get back to Judge Esteves' point and specifically with respect to the definition of survivor in the statute that Lonnie points out, because I think, as the judge says, it's, at least my reading is not all that clear, although I'll be the first to admit I don't practice in this area. So Justice Christopher.
Yes, I was looking at the comment to Rule 510, and apparently the mental health information privilege was enacted in Texas in 1979. And it appears that we then wrote a rule of evidence to cover it. And so my question, because I haven't really studied the rule that well versus our privilege rules, is there a difference between what is in that rule and what the normal procedure would be in terms of a privilege? And I agree with Judge Estevez. This could be a huge number of cases, especially on the criminal side. And I don't agree with someone's comment that a criminal defense lawyer, for example, might know what kind of motion he has to file to get this information. So I don't think that they would. So putting it in the rules of evidence, I think, would be useful for them. And obviously we have rules in our rules of evidence that specifically apply to criminal cases versus civil cases. So I think we need to look at it a little bit more and consider those problems.
Thank you, Judge. Getting back to the point that Lonnie made about the definition of survivor, and Lonnie, make sure I'm reading the right section here. Survivor means an individual who is a victim of a sexual assault or other sex offense. That's how it starts, right?
Yeah, so I mean, this is 420.003 definitions, and it's the 8th item down. So survivor, yeah.
And then it says in meeting that definition, you can disregard two things. One, whether a report or conviction, whether a report was made or a conviction is made. I think they mean a conviction of a perpetrator occurs. But to Judge Estevez's point, in the definition, survivor means an individual who is a victim of a sexual assault or other sex offense. Is it sufficient for somebody to come in and say, hey, I was a victim of a sexual assault, and now I have this privilege? Or does there have to be some determination by a fact finder that this person meets the definition of survivor and therefore gets the privilege? Is that what you were raising, Judge Estevez?
Yes, exactly, because sometimes that's what's being litigated.
Yeah.
And they need those to determine it, whether or not there was a sexual assault, because the fact finder is going to determine that.
Right.
Okay, I mean, I guess my reaction to this is really, I guess it's the same as what I had before. Maybe I just need to elaborate a bit. Is and I think Buddy already said it pretty well, which is whether we think this was a good or a bad statutory change, whether we think it was ambiguous or not. I mean, by the way, I could make an argument that it's totally not ambiguous, that the legislature is being clear that it's not only for people who say they were victims and can prove it, but just simply people who say they were victims. But again, whether I'm right about that or not, I mean, this is what we've got to deal with. And so it's not clear at all to me how we're going to resolve any of this with some sort of line drawing in a rule. And then the other thing I'll just add, and this was a place I had hesitated before, but it may we take a look at this, is under federal law, under the Victims Against Women's Act, from my early research that I did for part of this, it looks like federal law under VAWA already provides confidential protection privilege for both victims of domestic violence and of sexual assault. There are several Texas Attorney General opinions that recognize VAWA's confidentiality protections are enforceable under state law. Now, again, I haven't dug into what that means and how they're enforceable and whatnot, but I mean, there's sort of additional layers here. Again, none of which I think a rule would address. We wouldn't address it in any other rule. And then the only thing I guess I'll just add is back to Tracy's point. You know, Tracy, I hear you, but I also that it may be of some value to some practitioners to have it in the rule. But again, as Professor Good has said, there's all sorts of evidentiary privileges that aren't recognized explicitly in the rules. And so why we would add this one and not another is not as obvious to me. And many of those are also statutorily based, not all, but many of them are.
Can I just respond to Professor Hoffman? So I'm sorry, I'm not as articulate as all the the people that talk for a living, but what I wanted to say was that my question, I started off with a question, and the question was, if they have defined what a survivor is under any of these other statutes, then I think the most important thing we can do for a practitioner is to let them know that that's been defined and that this privilege wouldn't apply if it's an alleged victim and you're actually litigating that issue. So it is, if it's there, since the legislature didn't put it specifically in this statute, if they had done it in the family violence statute and there's already case law and we can point that out, that would be more important than letting them know that this privilege exists. It's to let them know that this privilege does not apply to that specific type of scenario. So that's why it was important, not because I was trying to change what the legislature did or I disagreed with them, but because if there's been an interpretation already on that survivor issue, it would be imperative for the judges to know when they go through these cases that if we looked at a rule of evidence and it says they have a privilege, we don't just say, nope, you're not getting that in. We need to know that there's that exception.
Okay, fair enough. I don't know who had their hand up first, but I think the order was Richard Munzinger, Robert Levy, and Justice Christopher. So we'll go in that order. Richard.
Judge Estevez raises a very, very, very important issue, in my opinion. Does the Texas Supreme Court interpret statutes by making a comment to a rule of civil procedure when the statute itself needs to be interpreted by, because the legislature wrote it the way it wrote it? I don't see how the court can write a comment even on this rule without addressing the problem of definition. And if it is doing that, then it is resolving an issue that I believe should be resolved in litigation. I think Justice Estevez hit a home run here. You got a real problem. If you come in here and say he sexually assaulted me, he hasn't been convicted. The other two provisions in the rule that have been read don't apply, but they don't apply to the situation that we're talking about. So how can the Supreme Court write a rule or a comment without interpreting the statute, or at least admitting that the statute is ambiguous? And I don't know that that's the Supreme Court's job, to tell the legislature that they blew it.
Okay. Robert.
Well, I look at this issue, the specific one that we're discussing, in a similar lens that I looked at the issues on the Chapter 98 questions about claimants' confidentiality. I think, at least my view is that the court should draw this more broadly in terms of what I believe is the intent of this statute and the others on a similar vein, is that we want to encourage victims, alleged victims, to bring claims, to be able to testify, to have confidence in their protection and the application of the privilege, and that we would not want to place any preconditions or suggestion that they have to prove that they are a victim before they're able to benefit from the statute, similar to the fact that they can bring a claim notwithstanding whether there's been an adjudication that there was trafficking, for example. So that we should suggest a broader application and not a threshold. In the way that Professor Hoffman read the statute, it seemed that there is no requirement that you prove that you are a victim or there's any adjudication. In fact, it would seem to be that there wouldn't necessarily be an adjudication for the privilege to apply. So I think that a trial court would have to assume that the person was a victim and apply the privilege accordingly.
Justice Christopher.
Well, looking at 420.074, talks about disclosure of privileged communications in criminal proceedings. So to me, that would seem to imply that we were talking about a victim where there has not yet been an adjudication that they are a victim of sexual assault, because at that point, there's just a contention that they're a victim of sexual assault. I would assume that. And, I mean, this is a very different procedure that puts the burden on the lawyer for the criminal defendant to file this motion. And I just think that this needs to be flagged for criminal practitioners at the very least. So that's why I think it should be in a rule. And in terms of, Buddy saying, well, where should we put it? Well, we're kind of, it's difficult because of the numbering. We haven't, left us any room to add a new number, but frankly, I'd make it a new number.
Harvey.
And the issue is to whether it would cover somebody who is an alleged victim as opposed to an actual victim. I think that it's possible the legislature wrote this very carefully, and it is delegating that issue to the trial court. Now, let me tell you what I mean by that. Rule 104A of the Rules of Evidence says, trial judges, you make the preliminary determination as to whether the privilege applies or as to whether something meets a rule. So, for example, when somebody claims attorney-client privilege and the other side objects and says, no, you were giving business advice, not legal advice. Well, that's a fact determination. And the judge makes a preliminary ruling on that. And based on that preliminary ruling, the privilege applies or it does not apply. Whether something's an excited utterance, the judge makes a preliminary ruling. So lots of these rules have these preliminary rulings by a court. And so it might be that the legislature was saying, we're not going to say that everybody who alleges that they're a victim gets this. It might be they're saying, we want some type of safeguard, but we also want the judge to look at it first. So I'm not sure that it's as vague as we think it is. It might take education for people to understand how that procedure works under Rule 104A, but the rule does provide a procedure within it.
Justice Gray asks, why would the determination of whether the person was a victim be any different than the application of an attorney-client religious advisory patient doctor? The decision of the application definition is decided. Judge Brown is now making my point. If the judge says no, yes, privilege, then potential mandamus. And what I took to be a smiley face is in fact explained to me to be by Justice Gray, just something that he has to hit in order to get his message sent to us. So now the record is complete on that. And I think Richard Munzinger and then Judge Peoples.
I respectfully dissent from Harvey's comments. The point at issue is whether the person using the language of the statute, quote, is a victim, close quote. Not whether advice has a particular nature as business or legal, but whether this is a suit where Jane has sued Bill, claiming Bill sexually assaulted her. That's the nub of the case. And so the trial court, if Judge Brown is correct, makes his preliminary decision in his own mind that the plaintiff wins the case to apply the privilege. How can that be? How can the judge make such a decision without having heard all of the relevant evidence? I'm a defendant. I've got a right for the judge. Judge can't make a ruling on the merits of my case without having heard all the relevant evidence. He shouldn't be able to if due process means anything. And if judge justice means anything, when the legislature says a person is a victim, victim has a meaning. We deal with words. The Supreme Court all the time says, when we interpret a statute, we figure the legislature knows what they're saying. And so we're going to apply the English language as it's written and as they wrote it. And all we're doing here is attempting to dodge that to create a privilege to an alleged victim as opposed to a victim. And so you've ruled on the status of the person claiming the privilege to apply the privilege when that's the nub of the lawsuit. And that's Judge Estevez's problem that's the way I read it, at least. And I don't see how you can possibly write a rule that lets, the Supreme Court can write a rule that avoids that discussion. We are bound by what the court is bound by what the legislature wrote. The legislature did not say, create a rule or create a comment. My personal recommendation to the court is let it work its way out in the court and don't say anything. I'm finished. Thank you.
You bet. Judge Peoples.
Two or three things. Courts and trial courts especially interpret vague statutes all the time. And I think that's what has to happen here. I doubt that the Supreme Court will want to interpret this statute by rule. I would point out, secondly, that the only time this comes up is when the person who says I'm a victim went to an advocate. We will at least know that that's what it's all about, their discussions with the advocate. And then the third thing I would say is, as a trial judge, I don't need a list of privileges because the only time I have to rule on it is when somebody makes an objection at trial or before trial. And so from my point of view, I don't need a list, but I would find a list of these privileges very helpful. And I wouldn't know the first place to go other than Professor Good's treatise on it or his handbook on it. But I think to mention, as Harvey Brown said, or maybe 501 is good enough, but just to have a tentative list, maybe it's incomplete, maybe something will be left out. But if that happens, you just add it later. But I think for practitioners, just a summary of what's out there would be helpful. And we got to muddle our way through on the rulings, but sometimes you take a baby step.
Judge Esteves.
I just want to make the point that the place I see this the most has been a parent charging the other parent. They're charging the other parent of having sexually abused one of their children, and it's been their greatest defense has been those counselors that have come in. And so, if it's privileged, it's privileged. And if they're an alleged victim, the child's not running around thinking about how am I going to make my case better? Or who's going to be looking at my files later, like an adult. And so I think that this is such an important issue that I appreciate everybody that supported that, that they don't, it's going to make a huge difference. And if we already know the answer to that, I just want to say we need to let them know. And I'm going to agree with Chief Justice Christopher. The reality is that our defense attorneys will not know what to do. Most of them won't, unless they happen to go to the CLE that specifically told them what to do. I mean, they're not going to get that information. They're going to mess up. We're going to have, even our appellate lawyers may not know about it. So we're not going to have a way to make them learn what to do in these type of cases. So we probably do need a rule for them anytime we're dealing with the criminal defense part, just because that's just our reality.
Thank you, Judge. Levi.
Judge Esteves's example there of parent versus parent. Now, I don't practice in family or criminal, but any privilege can be waived. And it seems to me in the example she cites, it wouldn't be one parent or the other who would have the right to assert the privilege. I don't know if an ad litem is appointed in such cases. Then it's the ad litem's decision. But I've gone in the context of a week from being a proponent of a rule to a proponent of a comment to now I'm persuaded by Richard Munsinger and in part by Harvey Brown that we should do nothing, at least for a period of time, because if we do nothing, we are still giving the sexual assault victims the same treatment that domestic violence victims are afforded. And that gives us some time to let the cases percolate and to get some opinions from the intermediate courts at a minimum. And it also gives the Buddy Lowe subcommittee, of which I'm a member of, the opportunity to debate with the State Bar Committee, and whether it's September 3rd, we come back with something, or some date later, the court need not rush, because we'd be complying with a statute by taking our time to think and debate. That's all I've got. Thanks.
Thanks, Levi. On the timing of our work, I went back and reread the reference letter, and on the topics that we're talking about today, the court said we should conclude our work at this meeting. I doubt that the court would have much trouble with us taking an extra week or so to suggest a comment if that's what the subcommittee and the full committee thinks is right. But running it out until our next meeting, I don't think was contemplated by the court. But if the court wants us to keep studying, that's fine. But the reference letter said we were to conclude our work today. So I offer that as a point of information.
Well, maybe our subcommittee chair could make a motion for leave to extend.
I would so do, but I've heard enough from my committee members to think right now, a majority are going to say do nothing. Now, are we supposed to draw a comment anyway if we vote to do nothing?
Well, we faced, this is not the first time we faced that, Buddy. And sometimes the court says, got it. We understand your recommendation, but go ahead and draft something anyway. And we'll hear from Justice Christopher, and then maybe ask the chief if he has any direction to give us both on, should we draft a comment? And number two, do we have any additional time? And if so, how much to do so? So Justice Christopher.
Well, unfortunately, there will be waiver in the appellate world. And so we will not see any criminal decisions, any decisions on the criminal side very soon. Because if the criminal defendant's attorney doesn't follow this rule to try and get the information, then there will be waiver. So that's why I consider that particularly important on the criminal side.
Thanks, Judge. Ken Sullivan.
I just wanted to weigh in very briefly on what I perceived to be the Tracy Christopher and David Peoples side here. Certainty is good. Plain language is good. User friendliness is good. I think the idea of doing absolutely nothing and just sort of letting some cases bring forward issues. It's one thing when you're dealing with a case in which there's uncertainty as to the outcome. That's every case. It's another thing when there is uncertainty about core issues of process, and the litigants become cannon fodder in that sort of uncertainty. I think we need to look at this from the user point of view, and we need to at least provide some reasonable amount of guidance here and weigh in. That's it.
Thanks, Kent. Well, on the motion by the chair of the subcommittee, who's also vice chair of this committee, for an extension of time to draft and propose a comment, I will kick that to the chief to see whether he and the court would find that helpful, or whether we are to, as the letter said, conclude our work today.
Well, I think it would be most helpful for me and at this point, and Jane, and at this point, I think you've pretty well aired your ideas, just to have an understanding of what the considerations are. And before I think we ask you to do more work on it, I think we probably should talk about it with the court and kind of get their view on it. Because I don't think we could comfortably speak on the court's behalf, given all the various considerations that we've heard, without laying it out to them first.
Great. That is good guidance. So we will, at least for the moment, conclude our work on this matter. And I'll ask Bobby Meadows, who I saw that joined us. But before I ask him anything, Harvey has his hand up. So Harvey, do you have a comment?
I just had a question for the chief, and that is, would it be helpful to the court to kind of do a preliminary survey or vote, if you will, to see how many people fall in each of the three categories? We have the do nothing, the right of comment, and then we have the right of rule. 3 different ideas out there. Would it help the court to get a sense of the committee as to people's preliminary reactions?
Sure.
Okay. Everybody who's in favor of do nothing, raise your electronic hand. Anybody else? Okay, has everybody voted? All right. Everybody who's in favor of, you can lower your hands. Everybody who is in favor of a comment, raise your hand. Has everybody voted that wants to? Okay, lower your hands. Everybody in favor of a rule, raise your hand. So everybody voted that wants to? Okay, you can lower your hand. Let the record reflect that the Do Nothing Party received 17 votes. The comment crowd received 11, and the Rules group garnered 4 votes. And the chair didn't vote. So that's where that came out. And anything else on this topic?
I just want to say this is the highest litigated area in the whole state of Texas. If you're going to have a lawsuit, whether it's criminal or family law, it's going all the way through the jury trial if it's a sexual assault case. That's all. It's very important.
Thank you, Judge.
Jeff, I have one question about my instructions, or wait to hear from the chief. Is that correct before we do further?
That's correct.
Yeah.
Okay. Now, with regard to the state bar committee, I have them go ahead and work or not.
Well, my own view would be that that's up to them. But if they're doing it for our benefit, they're using their resources in a way that's not helpful to us because our work is finished for the moment. So if they want to do it for their own benefit and get that input to the court, then that's fine.
Okay, I understand. All right. I'm sorry that all the other things went so smoothly, and I happened to draw this one, but I had help. Thank you.
Okay. And Robert has a question about the protection of sensitive data. I think whether there should be more work done, and I think I'm going to predict that we're done for now, Robert, unless the chief thinks we need more work. But I think for now we're done on that.
I agree.
Am I right about that, Chief?
Yes.
Okay.
Thank you.
All right. And so now back to Bobby Meadows, who I saw entered the fray here a little bit ago. And Bobby, your items are coming up next. In the last two items on our agenda. Do you have scheduling problems, or would it be okay if we took a half-hour lunch right now?
Perfect. No, we're ready to go, and a break's fine.
Okay. You look like you're at a construction site.
Well, I am actually. I'm in Montana, and we're wrapping up a little project here.
All right. Good for you. Well, it's 12:35. So why don't we reconvene at 1:05, unless that's not enough time for everybody to get lunch. Is that sufficient time for everybody? If anybody thinks it's not enough time, raise your hand. No hands have been raised, so we will reconvene at 1:05. That would be 30 minutes